So the state of California has introduced a new bill, AB 2571, which seeks to create civil penalties for any firearms industry member who is marketing to minors, and this is simply another way for them to try to get around the PLCAA and sue gun manufacturers into oblivion. So let's talk about this. But real quick before we jump into this video, if you think the state of California needs to stop violating our rights to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, in this video, we'll be talking about a new bill that has been introduced into the state of California, which creates a civil penalty of $25,000 per violation for any manufacturer or gun industry person who advertises to minors. If this structure sounds familiar in some way to you, that's because it is. This bill that California is introducing is similar in nature to a bill that was put in place in Connecticut that then helped and led to a $75 million settlement against Remington. These types of bills seek to create a backdoor civil lawsuit mechanism where the state or individuals could sue gun manufacturers under the state law despite the federal protection gun makers have under the PLCAA. Now, if you're not aware, the Protection of Lawful Commerce in Arms Act, or the PLCAA, is a U.S. law that protects firearms manufacturers and dealers from being held liable when crimes have been committed with their products. One important thing to keep in mind, though, is that these companies and dealers can still be held liable for damages resulting from defective products, breach of contract, or their own criminal misconduct. This federal law, however, has protected gun manufacturers and industry members from being held liable for conduct they have no part in. However, one new strategy anti-gun individuals have moved towards is bringing state-level lawsuits, civil lawsuits, against gun manufacturers based on things like negligence in marketing. And that is exactly what this bill involves and is trying to do. This bill, AB 2571, states, the bill would prohibit a person or entity that publishes materials directed to minors in the state in any medium or publishes advertising or marketing communications from marketing or advertising firearms to minors as specified. The bill would also prohibit the use, disclosure, or compilation of a minor's personal information if it is intended to market or advertise a firearm to that minor. The bill would impose a civil penalty of up to $25,000 for each violation of these provisions. Therefore, the bill establishes a person, firm, corporation, partnership, or other organization publishing material directed to minors in any medium, including but not limited to print or broadcast media, internet-based media, or video games, shall not market or advertise in that material any firearm, handgun, ammunition, or reloaded ammunition. Now, what are the standards established for when a company or manufacturer is marketing to a minor under this bill? Well, the bill states, in determining whether marketing or advertising of firearms, handguns, or ammunition, or reloaded ammunition is directed to minors, a court shall consider the totality of these circumstances, including, but not limited to, whether the marketing or advertising A. uses cartoon characters to promote firearms or firearms products, B. offers firearm brand name merchandise such as hats, t-shirts, or stuffed animals for minors, C. offers firearms or firearms accessories with colors or designs that are specifically designed to appeal to minors, or D. is part of a marketing or advertising campaign designed with the specific intent to appeal to minors. So the bill establishes some standards for when it is marketing to a minor, but really, it's all within the discretion of the judge in the court to look at the so-called totality of the circumstances, and then that judge, often that left-leaning judge in California, gets to make the determination whether or not this company or gun industry member or manufacturer, whoever, was in fact marketing to a minor. To go even further, this bill even extends to purely online-based marketing. It defines internet-based directed to minors to mean an internet website, online service, online application, or mobile application, or a portion thereof that is created for the purpose of reaching an audience that is predominantly comprised of minors and is not intended for a more general audience comprised of adults. So even companies purely outside the state of California could find themselves subject to California civil liability lawsuits because maybe someone could argue that a portion of their website or social media base or whatever is actually aimed in marketing towards minors. So as you can see, this bill really has a lot of vague catch-all ideas and phrases which really leads to the ultimate goal of dragging more firearms manufacturers into courts. Again, this is all being done despite the PLCAA's express protection of gun manufacturers. We knew that there was the potential that more of these types of bills would pop up, especially after the Texas abortion law was heard by the Supreme Court, and we knew that this could potentially open the door for more private civil liability lawsuits against gun manufacturers. We saw California also introduce AB 1594 that seeks to make a gun industry member liable for creating a so-called public nuisance if their failure to follow federal, state, or local laws causes injury or death, if that gun industry member engaged in unfair business practices as well. So again, they tried to create this bill that had this public nuisance language to drag gun manufacturers into court as well. However, I think it's important to note that this new bill, AB 2571 and others like AB 1594, are not Texas abortion clone law bills because the Texas law left the enforcement of that law purely to private citizens. The Texas law SB 8 was designed in a way that shields Texas and its executive officials from pre-enforcement lawsuits, since the statute allows only individuals to bring lawsuits, not the state or any of its officials. The enforcement mechanism of the law was designed in order to make it harder, if not impossible, for the law to be enjoined, since the state would play no role in the enforcement of that law. These California bills, in contrast, leave authority in the state attorney general to prosecute these violations. Now, again, that's much different from the Texas law, because the Texas law said it was a lawsuit, the power of which was going to be granted to the individual citizens. But these laws in the state of California still have an enforcement mechanism that is purely within the state's authority. So much different, but again, still ramping up lawsuits against gun manufacturers. Now, just because AB 2571 isn't an SB 8 Texas-like bill doesn't mean it's still not bad. It is really bad because it seeks to circumvent the PLCAA in a way that attempts to sue gun industry members into oblivion so that they no longer will operate in the state of California. It also seeks to create a structure that can lead to more lawsuits against gun manufacturers, and seeks to maybe even create larger settlements, more lawsuits similar to what we saw play out with the Remington case. Because again, Remington was sued for marketing to a specific individual to a minor in a specific way, and that was the whole basis of that lawsuit, and that was also what led to the settlement. So again, the state of California is trying to put in place a bill and a law that will allow for individuals to sue, or the state to sue under the same kind of concept, and maybe get the same type of settlements. So this is a bill that we definitely need to oppose. If you're in California, I would highly recommend you reach out to your representatives and let them know that you do not agree with this bill. You don't agree with this backdoor attempt to sue gun manufacturers despite the PLCAA, and you don't agree with them trying to hide these types of lawsuits behind shameful tactics like tragedies and children as well. This is not really about any of that. This is just about another way to sue gun manufacturers and to get around the PLCAA. So if we get any more information, I will definitely let you guys know. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could have ever thought. So thank you so much for all of your support. If you don't have a comment in mind, just comment down below. Your comment fuel the algorithm, and that really does help these videos. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will maintain by armed scholars.